Lord, may I have my lord's kindly to mention yesterday your lordships had been pleased to take up item number 5. No copy of the writ petition was served upon us from the CBI. And even after your lordship's direction, yesterday it was not served. Since during the course of hearing, my lord, the question came up as to whether in the social media, the photograph of the deceased can be pasted and some comments can be made. And lordship's desire was that the Joint Director CBI should file a report. And it was fixed
As to what can be done about
it was fixed on 18th. But unfortunately, my lord, yesterday in the evening, a scandalous allegation was made by this media about me, which is very much insulting to me, and I have never heard such thing during 46 years of practice, that I have submitted before your lordship that CBI has no separate cyber crime branch and it should be given to state government. Well, this is
that is not your submission.
That is being projected, and this channel, this Priyo Bandhu Bangla, made scandalous, scurrilous, defamatory allegations, and allegation is that I am acting in collusion with the state government. My experience at the bar before your lordships and before the other as Additional Solicitor General, I had the privilege to appoint highest number of CBI during the investigation. Your lordship has seen that, and even Arjiko's case also, I submitted on instruction that we are ready and willing to take up the investigation.
On the first day itself.
And before my lord, Mr. C. Rajasri Bharadwaj also I submitted, and my submission is recorded. But kindly clarify this, my lord. This is the item. Kindly clarify this so that I am not put into further embarrassment. This is the item number 5. Yesterday it was there.
This is a TV channel, is it?
Yes, this is the TV channel.
And who has given the interview?
No one was given the interview. Possibly the owner of the TV channel was himself dictating all these things, and restrain them from saying anything in future.
In fact, one of the orders we have said that that the media should not publish anything regarding that.
Kindly in this case, kindly pass this order, and my submission may be recorded that it was never my intention to submit before your lordship that CBI is keeping the liability to investigate on cybercrime. There is one national cybercrime reporting portal. CBI also takes help from that national. Do not kindly record that. Kindly record that and clarify.
In fact, same thing happened couple of months back with my photograph.
Yes, it also came in my WhatsApp. Not only your lordship's photograph, another Attorney General's photograph also.
I want 15,000 rupees today. You please send it now. By evening, I'll return it. I am the Chief Justice of so-and-so. So I went to that portal and did it. Last Wednesday, my son's Facebook account and WhatsApp was, the photograph was taken from there, and another WhatsApp number and another Facebook profile created asking for money. So once again, through the online portal, we have registered the complaint. And so far as in my case, they were able to trace it to a village in Rajasthan. In fact, there was a very big article in the India Today about this particular village, where all these sort of online scams take place. And it has got the highest number of SIM cards operating.
Correct.
And all telecom companies have got multiple towers in that village. And the only avocation of the youth is this.
In fact, there is a complete TV series on this on Netflix. This man is
similar thing happened with Justice Mukherjee also. Arindam Mukherjee. Justice Arindam Mukherjee faced a similar problem.
Yes, that also happened 2 weeks back. Justice Mukherjee. And we have lodged a complaint.
There's a friend of mine, Malad has 2 minutes of time. There's a friend of mine who is a medical student at KPC Medical College. His mother was called there from Kuch Bihar, said, this is your daughter? Yes, every details are correct. Every details are correct. They're saying your daughter has been arrested from a red light area in Kota. That's in Rajasthan. and that happened at midnight. So you pay me this amount, and the WhatsApp status and everything reflects that of a police officer. This is a very prevalent crime that's going.
All right, but then this TV channel is not a party in that.
No, I then will not kindly clarify this part only.
No, we list this writ petition alone to be mentioned on Monday. Though the other matters have been listed on 18, we'll dealing this alone.
Obviously, 2000. Yeah. 23. Yeah, Chair, that's right.
So what we have signed, I'm sorry, I have not yet signed this order. Therefore, we direct the seventh respondent, namely Joint Director CBI Kolkata, who is now taken over the investigation in the case, to look into the grievance expressed by the petitioner only with regard to this issue. That is with regard to the photograph and issue, as all other issues in the writ petition stand satisfied in the light of the orders passed by the Honorable Supreme Court. In this regard, a report may be filed by the seventh respondent or any other officer who has been empowered to file an affidavit on behalf of CBI. Let this matter be tagged along with the batch on 18th September. That's what we have said.
And your lawsuit desire was on the next occasion.
Yes.
Your lawsuit should be decided about the cybercrime issue.
No, on the next, what the understanding was, CBI will say, this is the methodology to.
Methodology, yes.
Then we can issue direction.
Yes. But I am praying subject to lordship for
But
your
who
lordship.
appeared the other day? Mr. Subhatra Chaudhary.
No copy is served upon me as yet. But I do not want anything else. Only it is to be clarified that it was not my submission. Kindly make it.
List this matter under the caption.
No, today, kindly make it today. Otherwise, the other news channels may follow this channel and
But
go
today, how to get if you are able.
The other side is not affected by this. If you lost,
At least he should know that the matter is listed in the supplementary list. If your juniors can get any one of the advocates for the petitioner, we can clarify.
Today supplementary list.
Yes. You try and find out. Otherwise, on Monday it will come.
I may have your lordships kindly
Hmm.
to mention, my lord, item number 85 of your lordship's list,
Hmm.
original side list, my lord.
Hmm.
This matter relates to that provisional release, my lord. In
Oh.
1 year, that 4 kgs of gold. It was subsequently once remanded back by your lordship.
Gold prices are falling down, so it is in safe.
No, but we have an export obligation. We are not sellers. We export it.
We'll do something next week. Upgrade.
My lords, kindly.
Any day convenient to your lordship.
Done.
I'm mentioning upon notice to Mr. Ponjo.
My lords, kindly leave to mention this matter, my lord. Last Friday, I had mentioned this matter because my matter was dismissed last Thursday. There was some technical glitch for which I could not appear online.
Hmm.
My lord said that my lord did not sign the order, hence there is no question of filing a recalling application. That order will not be signed. The matter would be posted today. The matter would be listed yesterday. That is on Thursday.
Unfortunately, it's signed already. List it on Monday to be mentioned.
My lord, requires a recalling to be filed.
Not required. We'll see.
Grateful, my lord. My lord, writing over the mentioning slip.
May I have your lordship's kind leave to file this up?
If the other side had appeared, you please bring them.
Yes, I'll serve notice and come back.
Please. It's yes.
Grateful.
May I have your leave to file this appeal without the certified copy, lordship?
Yes.
20 minutes.
You have applied for the certificate copy.
Lordship, we have applied for somebody. I have annexed the same with you. It's an appellate side matter.
Yes.
The kind the customs appeal manner, while we have a date for release of gold manner. It's an admission set.
Admission. Definitely.
By your lordship, 30th August, there is a mistake. It was mentioned that the order of the same should not income tax affiliation. Second para, second line.
You can put it today, August.
That the order should be caused by Clerical city. Order of the income tax affiliation. Instead of single that.
This matter has been listed in the supplementary list under the caption to be mentioned. it is pointed out by the learned advocate appearing for the respondent assessee that in the order dated 30th August 2024, in paragraph 2, line 3, it has been mentioned the learned single judge, inverted comma. This is a mistake, as it is an order passed by the Income Tax Appellate Tribunal. Therefore, the words learned single judge shall be deleted and substituted by the words Income Tax Appellate Tribunal. This order shall form part of the order dated 30th August 2020.
But I'm appealing for the appellant.
Yes. Prithu Doria, Om Narayan.
Yeah, my lord's kind leave, my lord. I'm mentioning upon notice, my lord, this matter had appeared in the list on 30th of August, and as item 24, but I could not appear for a personal difficulty, my lords, and it was made not today. But from the case status, it appears it is appearing, my lord, on it is scheduled to appear on 20th of September. The difficulty is, my lord, it's a transfer, my lord, case which we have. The issue is 127 of the Income Tax Act, my lord. The department in
I
Delhi.
think we have spaced all those matters. That is what
I understand that, my lord. It is my fault. I should have appeared before your lordship that day. My lord, Mr. Arjok Dottu was appearing on the other side. But for my difficulty, my lord, I could not appear. May I only pray for this, my lord, any day, because the difficulty is, my lord, if the Delhi authorities proceed with, my lord, passing the order, then the entire proceeding becomes infructuous, my lord.
you have to list it as to be mentioned, and then we'll see. What we can do is we list it on Tuesday. Original side matter.
Original side matter, my lord.
Wednesday.
Wednesday and Friday.
Under the caption to be mentioned.
Lordship.
Mr. Dutt is ready that day. We make something.
I'm very deeply obliged. My lord, we'll also inform Mr. Dutt personally. My lord, we'll do that. Very deeply obliged, my lords.
Yes.
This is appellate side matter for appeal. This should be included in the cause list. It should appear.
My lord, may I be permitted to mention on an original side matter? The matter was to be appeared on 6th September, but it did not appear.
That sir, appellate side matter to be mentioned. That you call.
Appellate side daily list, serial number 1, under the caption to be mentioned.
But he is appearing from Jalpaiguri.
I am appealing for election of India, my lord, in this matter, my lord. For election commission of India, my lord.
Which item you are appearing?
81, my lord. I don't know 1.
Item 1 in the appellate side or original side?
Appellate side, my lord.
Yes. Mr. Chaudhary is here, no? Actually, no, we passed another order, no, dismissing the petition as withdrawn. That order is not yet signed. But yesterday order. See, Mr. Chaudhary, you are able to hear us. I think your mic is muted or something.
Learned advocate Mr. Chaudhary, please unmute.
We are not able to hear you, but actually what has happened is, as per the Calcutta High Court Circuit Bench at Jalpaiguri Rules 2019, public interest writ petition can be moved only before the principal seat. So we will recall the yesterday's order, which we are not yet signed, and we will list the matter for admission on Thursday. You can appear online. But we are not able to hear you, sir. There is some problem in your system at your end. You are able to hear us? So the matter will come on Thursday for admission.
My lord, my lord, I have prayer, my lord. Kindly fix the next Friday, my lord, not on Thursday, because I'll be out of session, my lord. Because I have to submit for election commission in India, my lord. It's my prayer, my lord. Kindly.
But it's a PIL, no?
Yes, my lord.
But it Friday is original side day.
Or as the lordship is, I'll try. I'm grateful, my lord.
Oh, we have already passed it. Okay. So what we'll say today, nothing we have to say. All right. We'll say list the matter on. List the matter on Thursday for admission. This rule also keep it inside. Now appellate side. No, original.
Let my name be recorded kindly.
Yes.
Anuran Shamantu. I have given it chat box, my lord.
Before my lord takes up original side, may I have my lord's kind leave to file one application. I have moved this matter, seeking leave, my lord, before 3 days before, my lord. The difficulty is with the code, my lord, with regards to any matters pertaining to society. Now, again, with regards to the prayers mentioned therein, my lord, this matter is getting difficult to be filed in the residuary as well. Under the filing department is saying that you file it under cooperative society, but then that is not the case here. My lord,
But
kindly,
what can I do about it?
kindly, my lord,
Do file it under cooperative. Let it go before the cooperative bench. You tell the cooperative bench, no, though it is a group 9 matter, they will release it
the
automatically.
only difficulty is that there is a huge defalcation of funds here, and I'm talking about a sum almost about 20 lakhs here. My
I
lord,
can't do anything on the administrative side. The only thing is you file.
there's a grave urgency, my lord. That is the only reason I'm.
Nothing will happen. Defalcation has already taken place. Anyhow, after notice, you file
Yes,
it.
very well, my lord.
Yes. Please call.
Lordship, am I audible, Lordship? Item number 1, Lordship.
Yes,
Lordship,
yes, now you're
Lordship,
audible, Chaudhary.
Yes, Lordship. Lordship, this writ petition already admitted, Lordship. Hearing was going on. Affidavit of service has completed, Lordship. The last day, the state respondent had taken the time for necessary instruction from their client. That was happening, but it was prior 6 months. It was most probably the date was, Lordship, 25th 4/2024, Lordship.
No, we will hear you. See, we had passed an order permitting you to withdraw the matter and file it in the circuit bench. But as per the rule, the PIL has to be filed in the principal seat. So we will hear you on Thursday.
Okay, Lordship. Much obliged.
Yes, please call.
Original side daily list item number 1 and 2.
Is appearing at my instance. No? This your lordship would recall. This is the MSME that
Yes,
is
yes,
before
don't start from A for apple, B for.
No, not sir. I'll come straight to Z. My lord, pursuant to your lordship's order, they were
have given a calculation.
They have. Kindly have a look at the calculation. My lord, your lordship's order of 11th of March 2024 records that I am a charitable hospital.
No. Last time your colleague said 35 lakhs is 45 lakhs.
35 lakhs, 30 lakhs. 30 lakhs was as on January 2024 at 10% per annum. If I bring it up to today, it comes to about 36 lakhs. They have given.
We'll round it off at 50. 50.
My lord, may I come back with instructions?
No, they've given a chart. Your lordship has seen the chart of
last
1
time
crore
also
odd lakh.
submitted the yes.
They've agreed to 50 on the last occasion.
Possibly subject to correction, my lord. There was no agreement.
No agreement at all.
My lord, on the last occasion, 40 had fallen from then. I had taken
We are
instruction.
making that 50. In fact, your colleague, senior colleague who appeared, you said,
Yes.
This is our proposal, but we bow down to your order. That's what he said. You want to see the recording also.
No, I don't think.
So we are not compelling you.
I do not.
What is your instructing counsel is not agreeable.
No, lordship. Not agreeable. Lordship, that is the instruction that I am getting.
Not agreeable. This particular amount.
So that it's a win-win situation, sir. But for the court order, you would not have got the principle, no? But for the court order, you would not have got the principle. You address the court. Mister, you address the court. Why are you addressing her? All right, you are instructing her and she is saying, instead of that, you can speak in the mouth.
Your lordship, actually, we have come down to 1 crore, 1 CR. So we will be okay with near about 60 to 70 lakhs.
We are suggesting 50 lakhs. We will do one thing. Let your client come. Your client is an MSME. Some director or somebody is there.
Yes,
Ask him to be in court. We will try to convince him.
Lordship.
the issue involved in this appeal now has narrowed down to the amount payable by the hospital to the MSME towards interest. A calculation was submitted by the MSME on the last occasion, and the matter was adjourned to enable the hospital authorities to get back. Today, a figure has been suggested by the hospital authorities, which has been conveyed to the learned advocate appearing for the MSME. Over and above this, the court has suggested a figure on which the learned advocate for the MSME shall obtain instructions. In order to give a quietus to the matter, we would direct one of the what is it? It is a company or partnership firm.
It is lordship of proprietorship concern.
All right, the proprietor of the MSME to be present in court on the next hearing date. That's on Wednesday. Let the matter appear under the same caption.
Very grateful.
I'm deeply.
Next.
Item number 3. In this matter, I appear on behalf of the appellant. Now, this is a very short matter on a short point. Lord, the petitioner, writ petitioner appellant, had a passport valid from 2013 to 2023. In the meantime, there were criminal cases against him. One was.
We'll hear the appeal.
Your lordship's pleasure was to direct that the appeal be listed today has to be mentioned.
Yes.
So that's why I was.
Today we are yet to take up the admission matters. No? If this goes on for half an hour, 1 hour, the admission matters will get stuck. So,
I fully appreciate that, but
there was some inconvenience for me.
No.
That is the reason the list got.
Yeah.
So we'll have the matter next week, next Friday. We'll see whether we can.
As the first matter.
Oh.
Because I tell you, lordship, because the passport is not being renewed, even after the orders of Delhi High Court and the.
But the request was dismissed.
We came to this court saying that in spite of that order, this passport is not being issued.
No, that is not the issue.
All right, list next Friday. On that day, the appeal will be heard. Immediately after fresh cases.
Immediately after fresh cases.
We'll take it up, sir. Don't do it.
New application tax matters, item number 4.
Is it delay, my lord of how many days delay?
230 days.
That I think they won't oppose. One page is missing.
Yes, my lord.
Page 6 of the ITAT order.
Two pages, my lord, in fact. Two pages. But we shall supply that. My lord.
We'll condone the delay today. We have heard Mr. So-and-so, so-and-so. There is a delay of 230 days in filing the appeal. The learned advocate for the respondent would vehemently oppose the prayer for continuation of the delay, stating that no reasons have been assigned. Considering the fact that this appeal has been filed under section 260 capital A of the Income Tax Act 1961, and we are required to consider as to whether any substantial question of law arises for consideration, We exercise discretion and condone the delay in filing the application allowed. Let the matter appear next week.
Lord,
I only want only this.
No. Where is the counsel for the writ petitioner? Your junior colleague can get him over the phone. The file, where is the appellate? You give the mobile number to ASG's junior, that advocate's mobile number. No, in his presence, we'll pass the orders. Ask him to be here for 5 minutes, please.
Lord, affidavit of service, my Lord, may be kept.
Yes, after
Please.
Restoration application item number 5 and 6.
Well, the service is delayed. Dr. Chakraborty is appearing for the respondent. He has requested if the matter can be fixed on Wednesday, he will.
This is dismissed for
dismissed for default, due to non-appearance.
We'll restore it. You inform Dr. Sir. There is no delay in filing.
Yes, there is some delay. That is the reason. 109 days.
Oh, it's a public sector. What is the issue? Anjani, give the stay petition and memo.
It's a question of loss. State memo will the name out. The amounts to manufacturer is not. In the superior correction.
Well, the question of law is at page 5 of your lordship's stay application, whether 4 and
The superior correction does not amount to manufacturer. There is amount to
page 6, 4 and 5,
सर ये तो memo में भी कोई नहीं
whether intermixing amounts to manufacture.
सामने दिख रहा है
Correct order. Ultimately, you and I will be paying more. Both are cleared from the factory and duty has been paid on the value at the point of clearance. However, by transporting through pipeline,
It was intermixed.
it gets mixed. And the tribunal finds that there is no allegation in the show cause notice that there is a process of manufacture resulting in a distinctly different product. This is, and let us see the circular.
The circular has been mentioned in page 4, internal page 4 of the tribunal's order. 4 and 5. Lordship may fix it up on Wednesday, thereafter you learn.
This will have a cascading effect, sir. It's a public sector. Ultimately, the end consumer will be affected.
On Wednesday, let them come, my lord, I shall.
No, we will finish it today. We'll restore the appeal. We'll close the matter.
Well, there is also a delay in the
Filing the appeal.
yes, ma'am.
This application has been filed to condone the delay in filing the application for restoration. Though the reasons given are not very satisfactory, yet since the appeal had been filed under section 35 capital G of the Central Excise Act 1944, way back in the year 2020, and the appeal was pending, and we are required to consider as to whether any substantial question of law arises for consideration. We exercise discretion and condone the delay in filing the application for restoration. Accordingly, GA 3 of 2024 is allowed. GA 4 of 2024 has been filed to restore the appeal which was dismissed for non-prosecution. We have perused the reasons given in the affidavit filed in support of the application, and we find the reasons to be acceptable. Accordingly, GA 4 of 2024 is allowed, and the appeals and the applications are restored to the file. GA number 2 of 2020
is a stay application.
No,
Delay.
There is GA1. GA1 of 2020 has been filed to condone the delay of 151 days in filing the appeal. Though the prayer is vehemently opposed by the learned advocate appearing for the respondent SSC, considering the fact that the court has to see as to whether any substantial question of law arises for consideration in this appeal, we exercise discretion and condone the delay in filing the appeal. Accordingly, GA 1 of 2020 is allowed. This appeal has been filed under section 35 capital G of the Central Excise Act 1944 within bracket the Act, challenging the order passed by the Customs, Excise and Service Tax Appellate Tribunal, East Zonal Bench, Kolkata within bracket Tribunal, dated 27/6/2019. The revenue has raised the following substantial questions of law for consideration. Where are the questions, sir? Page number 5 of the stay application, para 4, subpara 1, subpara 2, and subpara 3. Subpara 4 and 5 not required. We have heard Mr. Bhaskar Prasad Banerjee, learned senior standing counsel, assisted by Mr. Tapan Banja, learned senior standing counsel for the appellant, and Dr. Chakraborty, learned senior advocate, appearing for the respondent SSC. The respondent SSC, a public sector undertaking, Indian Oil Corporation Limited, filed the appeal before the tribunal, challenging the order passed by the Commissioner of Central Excise, Haldia, by which the proposal made in the show cause notice was affirmed, and higher rate of Central Excise duty was demanded.
Page 98. Is 98 of the stay application is the final.
Apart from the demand of duty, interest was levied, interest was charged, and penalty was also imposed.
No penalty was not.
No penalty.
No penalty. I refrain from imposing penalty.
Interest was levied. Full stop.
Right.
The issue which arose for consideration before the tribunal was whether
Different.
the revenue was justified in solely relying upon CBEC circular number 636/27/2002 hyphen C X dated 22/4/2002, stating that in the event of intermixing of SKO, instead of that, don't say SKO first, you say superior kerosene oil within bracket SKO with motor spirit within bracket MS / high speed diesel within bracket HSD during the movement of petroleum products through pipeline, the higher of the two duties, that is the duty payable on SKO and not used for the intended purpose, and duty payable on surge SURGE / gain of MS or HSD shall be payable for intermixed / interface quantity. The learned tribunal had elaborately considered the factual position and recorded the submissions made on either side. The tribunal also took note of the circular dated 22/4/2002 and found that the circular cannot vitiate the law, or in other words, the circular cannot be issued contrary to the statutory provision. The tribunal on facts found that the assessee have correctly applied the price of respective goods cleared from the factory at the time of renewal. The learned tribunal took note of the decision of the Honorable Supreme Court in Sindoor Micro Circuits Limited versus CCE Belgaum 2008 220/29 ELP 641 within bracket SC. Semicolon. Atul Commodities Private Limited versus CCE, Cochin 2009 235 ELT 385 within bracket SC, and DGFT versus Kanak Exports 2015 326 ELT 26 within bracket SC, for the proposition that the board cannot issue a circular contrary to the statutory provision. Nextly, the tribunal referred to considered as to whether the finding of the adjudicating authority that after removal of goods, intermixing of SKO with MS/HSD amounts to manufacture. The tribunal noted that there was no such allegation in the show cause notice, and therefore the adjudication order traveled beyond the scope of the show cause notice, which is not permissible law in law. Permissible under law. Not stopping with that, the learned tribunal also took note of section 2 within bracket F within bracket clause 3, which defines manufacture, and held that it will amount to manufacture only in respect of the goods specified under the third schedule, and it is third schedule. And it is undisputed that the products of the respondent assessee are not specified under third schedule, And therefore, whatever activity mentioned in clause 3 of rule of section 2 within bracket F shall not apply to the goods which are not specified in third schedule. Therefore, the tribunal came to the conclusion that intermixing of SKO with HSD/MS does not amount to manufacture. With the above finding, the learned tribunal allowed the assessee's appeal. We find the reasoning given by the learned tribunal to be perfectly valid and justified, as the board cannot issue a circular contrary to the statutory provision, nor the adjudicating authority can travel beyond the allegations with the show cause notice. Thus, we find no grounds to interfere with the order passed by the learned tribunal. Accordingly, appeal fails and dismissed, and the substantial questions of law are answered against the revenue. Same order for 6 also.
Yes, Malad. Malad, it will be a common order. We have only challenged in one appeal all the orders.
All right. It will be common order in item 5 and 6. The delay is also same.
Yes.
5 and 6 one matter.
5 and 6 is one matter.
Yes,
Same. Sorry, sir.
Malad, kindly clarify, it is a common order which we have challenged in one appeal. That will be better. Otherwise,
then in the first paragraph,
yes,
sir,
kindly
where
clarify.
we have said this appeal has been filed under 35G so and so, challenging the common order passed by the
that will cover it.
customs excise so and so.
Well, that is written over here. If the
yes, we saw.
It's a
next.
number.
For admission of tax matters, item number 7.
If I were to hear this matter at this stage itself, there's some difficulty which has arisen. My lords have been pleased to stay the garnishee notice. That it's been there for quite some time, and the main customer, excise, they are hesitant about doing any further business with me. So it's affecting them. I'm sorry to trouble my lords, but it's acquired some seriousness for the.
All right, we'll hear.
Gotcha. I'm grateful, Lord. Volume 1, 3, and yes, may it please, Lordship. The basic dispute is not the addition made on account of certain purchases made from 7 parties. But the SSC is manufacturing, amongst other things, refined lead and alloy. And the 3 raw materials which go into the manufacture of this. One is lead ingot, remelted lead ingot. Then there is lead scrap and lead concentrate. These 3 raw materials, they're different recovery rates in terms of conversion from the raw material to the finished goods. From the lead ingot, the recovery is 99%. But the other 2, it is lesser. So in the tax audit report, it's a requirement under the law that in the tax audit report which I file, which I submit to the department, I have to mention the yield, the recovery which has been made. I will show from the record that in the tax audit report, this particular yield was there. The yield was mentioned in a consolidated way in respect of all 3. Now the dispute here is with regard to the lead ingot which was purchased But from
Not in respect of scrap or concentrate.
Lordship. Now, I'm just giving the the broad picture. Then I'll take my lords into the documents. Not in course of the assessment proceedings, I was asked to furnish the income tax returns of some of these suppliers. So I said, look, I do not have their income tax returns, but they are. I've checked the GSTR portal. They have filed their GST returns. That data is there. So then he issued me a show cause notice, and that I had been allowed credit in respect of these purchases. So he issued me a show cause notice saying that there's no digital trail footprint because their emails are not available, so we cannot find them. And you show cause why this should not be added in your assessment. I was asked to give the transactional documents. I furnished everything. I gave all the documents, and he still went and his show cause notice said in the GSTR portal these sellers have reported a turnover which is less than what you have shown. They had shown some 45 crores, which is not including GST. After addition of GST of about 8 crores, it becomes 53. So the actual difference is some 3 crores, not the larger difference which they say, because they have reported it net of the tax. My accounting is including the tax. The tax is about some 8 crores. So that notice particularized all these things, and then in the assessment note, he added the amount, saying that they cannot be there's no digital footprint, no email address, they cannot be found, and takes note of my submissions regarding because I submitted the purchase details, the documents apart from documents, the quantitative details of purchases, consumption, stock, the sale of finished goods. I furnished all that data. That yield part was there in the tax audit report before the assessing officer. So he expressed the suspicion that looks like the assessees purchased elsewhere, but not from these people. But he nevertheless went ahead and added the amount, the entire amount under section 69C. Now that section 69C by itself, that section does not apply, because the section is invoked where I cannot explain the source of the purchase. That is money that I have paid. That source of that money, I have placed the section in due course. If I cannot explain the source of the purchase, then that amount gets added. But here, the source of the purchase is there in the books. They are questioning the purchases themselves. So this section itself, does not apply. I appealed before the Commissioner appeals against the addition. So the assessment, the sole ground was that these people cannot be, there's no digital footprint, no email ID cannot be. And yes, there's one other thing. He said that I'd send notices, and they could not be found. The record shows that one of them was served. He says one was served, but he didn't come. The other refused. So it's not that all 7 were not found. The record will show that one was served, didn't turn up, one refused service. But matter traveled up in appeal. In appeal, the Commissioner appeals called for a remand report. In the remand proceedings, I participated. Subsequent to the assessment, there was a action against the assessing, in which there was an investigation with regard to these suppliers also, it seems. So the assessing officer looked into the appraisal report and said that there are 2 of these people, apart from the other 2, one which was served didn't turn up, one refused service, 2 were found, but they had given statements denying the transaction. The entire statement was not furnished. Some questions and answers were extracted from those statements. One person said, I'll take my notes with the statement. One person said, I am a plumber. The other person said, I'm a crane operator, and they disowned. So when this was put to me, I asked for cross-examination. That cross-examination was not granted. In fact, the Commissioner records in the order as if my stand was that I don't need to establish their identity, and I'm I don't need to refute their statements. Whereas not I would submit the record will show that I asked for cross-examination. I was not that the transactions had happened, that these people existed, because it's entirely through the banking channel. It's not that there's any cash transaction. But the material is worth several crores. So that they existed at that point of time that these transactions took place, I have to show. But now if two of them have made self-serving statements, they have filed GST returns, but they have paid GST also. I've got the credit. Now, if they don't file income tax returns, but I omitted to mention this fact. The other ground the assessing officer said was that they had not filed their income tax return. That was actually the sore point, that they have not filed income tax returns, and therefore I came under a cloud because they had not filed their income tax returns. So the commissioner proceeds on the basis that I don't need to even, my stand is that I don't need to refute the statement made by them. He cites a whole bunch of decisions dealing with share capital and loans, section 68 cases, 7-8 pages of his order is devoted to those cases. But then he says that he said, yes, the assessee has said that, well, I have purchased the goods, I have used them, I have manufactured goods which I have sold. So then he said, no, they have given only broad particulars. I will show me that is not the case. Then he says, yes, it is possible, because the assessing officer had himself said so that goods were purchased from elsewhere, documents were taken from these parties. So he said that is possible, but then the assessee has to own up to that. The assessee has to say that which are the parties from whom they actually purchased, where did the money come from. So he said none of that is before me. So he sustained the entire thing. Now the matter travels up to the tribunal. But the tribunal has not affirmed these orders. The tribunal has taken the two statements as sacrosanct. In spite of my having asked for cross-examination, the tribunal proceeds on the basis as if they are the complete truth. Whereas I had all along disputed that. The relief which the tribunal has granted is not to, with regard to the GST credit, which I got. So that part they have deleted. The credit which was taken in respect of these purchases, that addition they have deleted. But this 48 odd crores, 45 odd crores, 48 crores has been sustained. The basic price of the goods on the basis again that I have not provided the yield. The tribunal says I have not provided the yield. The yield is in the tax audit report as to what the manufacturing process is yielded. That is there. Tribunal proceeds on the basis that what I have used is lead scrap. They say lead ingot. What I have used is lead ingot, but they say scrap, that is lead ingot. So they're confusing themselves by treating my purchase as of scrap and not of lead ingot. The lead ingot, as I submitted, the recovery for lead ingot is 99%. It's the other items where the recovery is on the lower side. The finding of the tribunal goes so far as to say that I have used undisclosed income to make bogus purchases. It makes no logical sense at all that somebody will use undisclosed income to make bogus purchases. The bogus purchases.
A double negative.
That doesn't make.
This is true, that cannot be true. That is true, this cannot be true.
One can use undisclosed income to make purchases.
So it can be a bogus purchase.
Lordship. So they have actually I will endeavor to show that they have the tribunal has not missed the facts. They've not taken the facts into account in the correct perspective. And even the commissioner appeals order proceeds on the wrong footing. One of the points is whether I am required to show creditworthiness of the persons from whom I have purchased. This is not a case of my taking a loan or my raising share capital. So he says that as a purchaser, I have to show the creditworthiness of my suppliers. No, my lord, I have received goods. I paid for the goods. Now, my lord,
But they can ask for the identity of the vendor.
that basic transaction I have to show has happened. I cannot, my lord, and that I did. My lord, I will show from the records. My lord, I just wanted to give an overall picture. My lord, maybe I missed out some points. My lord, may trouble my lord with the
yes, we'll go into
lordship. My lord, kindly, my lord, first take my lord, volume 1. My lord, I've request.
Stay application, yes.
Lordship, I would be referring to volumes 1, 3, and 5. My lord, these are the three.
One is this. It is 3. Fine. Ready. They'll join. Okay. You just inform me. Yes, sir. Volume 1.
Volume 1, if my lords are pleased to have not page 124, which is the first page my lord, of the tax audit report. And where
124.
124, my lord, where it starts. And just to show my lord where it starts, 125 is the first page my lord, of Form 3CD. Kindly my lord, now have page 138.
Yes.
Serial number 35. my lord.
In the case of manufacturing concern,
Give quantitative details of the principal items of raw materials, finished products, and byproducts. And what my lords will find with 35, the below that, raw materials. We'll kindly see the headings. Serial number, item name, unit, opening stock, purchases during the previous year, consumption during the previous year, sales during the previous year, closing stock, yield of finished product, percentage of yield, shortage. Now, this data is here. We are concerned with the serial number 2. Raw material for refined lead alloy. My lords will find that the figures are given, and in second last column, there's a yield of 88%. Now, below that, 35, the second part, finished products. There, can you see the headings? Serial number, item name, unit, opening stock, purchases during previous year, quantity manufactured during the previous year, sales during the previous year, closing stock, shortage, excess, if any. Now, here also, serial number 2, refined antimonial lead, lead alloy. So, for that,
refined antimonial.
Antimonial lead. Going on to the next page, antimonial lead alloy. And the figures are.
Yes, can you give us 1 minute, sir? There is one passed over matter.
Lordship.
Mr. Chaudhary, please unmute.
My lord, my lord.
Learned Additional Solicitor General is here. He made a mention today morning in your matter, saying that one TV channel has carried out a very wrong report, casting aspersions on what the ASG has submitted before the court. So we distinctly remember that initially we wanted to know what the response of the Joint Director of CBI.
My lord.
This is what we have recorded. But in the TV channel, therefore, the Learned Additional Solicitor General wants us to clarify, saying that because they are giving a wrong news.
My lord, this much I can submit, my lord, that none has taken any statement from me. So as such, I'm not sure.
No, we wanted to do this clarification in your presence. That is why we wanted.
Lordship.
The matter has been listed. Please take down. The matter has been listed under the supplementary list. on a representation made by the learned Additional Solicitor General of India, who had appeared for the CBI in the writ petition. The purpose for which the matter was mentioned before this court is by submitting that one of the TV channels, where is that letter, Kotak?
প্রিয়বন্ধু বাংলা চ্যানেল যেটা কাগজটা দিয়েছিলাম
one sheet of paper handwritten.
কাগজটা দিয়েছিলাম
One TV channel, so and so, had carried a news yesterday within bracket 5/9/2024, incorrectly reporting about the order which was passed in the writ petition. Therefore, the learned Additional Solicitor General requests the matter be clarified. In the said writ petition, there were varied prayers, and the court took into consideration that most of the prayers stood satisfied, and the limited and the issue to be decided was whether the direction sought for by the writ petitioner upon CBI to investigate into the angle of cyber offense being perpetrated in connection with the unfortunate and brutal incident which occurred could be granted. We had gone through the annexures to the writ petition, and we were of the prima facie view that the wordings adopted in the messages is far from being acceptable to any member of the society. Therefore, at the first instance, we wanted the response from the Joint Directors from CBI Kolkata, the 7th respondent, as to the prayer sought for by the writ petitioner. This is full stop. This was required because the investigation has been taken over by CBI. Therefore, we directed a report to be filed by the 7th respondent or any other officer who is empowered to file the affidavit on behalf of CBI, and the writ petition were tagged along with a batch of cases and directed to be listed on 18 September 2024. It is not clear as to how the said TV channel, Priya Bandhu Bango, had reported something more than what was recorded in the order. Therefore, accepting the submission of the learned Additional Solicitor General, it is clarified that the court had issued direction to the CBI, Joint Director CBI Kolkata, the 7th respondent or any other officer empowered to file an affidavit on behalf of CBI to file an affidavit so as to with regard to the prayer sought for by the writ petitioner to direct the CBI to investigate into the angle of cyber offenses. The press, while reporting, should verify as to the exact nature of the order and direction issued by the court, as the matter is a very sensitive issue and utmost care should be taken while reporting about any matter concerning the said issue.
And can you record, my lord, in your lordship's order, your lordships have not been pleased to record the issue of cybercrime at present.
You have recorded this.
Carefully.
The matter stands.
My lord, I pay unqualified apology for not being able to remain present in person, my lord.
No problem, Mr. Chaudhary. Yesterday, I was also on the virtual mode. That doesn't matter.
Good.
No, the matter.
But one thing, my lord, in spite of the lordship's order, no copy of the writ petition has been served as.
Mr. Chaudhary, please serve copy of the.
My lord, I'll take care that he will be immediately.
I'll have to communicate to the joint director.
Because they have to communicate. You ask your junior colleague to serve it today.
Not well. I'll get it served immediately.
Okay, yes. The matter stands clarified as mentioned above. list on 18th September,
Get full.
along with batch. Yes,
I'm
sir.
ready. I'm ready.
Yes, sir. Sorry.
But I was placing that tax audit report. This is the one which is not uploaded not on the net. There's a form. And there's also a physical version. But kindly have a look at the physical version at volume 5 not at page 662.
Yes.
But 662 is where that form 3CA, 663 is form 3CD. I'm not at page 670. 35, serial number 35. The 35B. In the case of a manufacturing concern, give quantitative details of the principal items of raw materials, finished products, and byproducts. And not the, so not here it is mentioned this annexure 11. I'll take my notes to that. And then what kindly see below that finished products, byproducts, capital B. A is for raw materials, B is for finished products, byproducts, annexure 12. So those are at page 672 and 673.
Yes.
Now, the difference between the electronic form and this is not here, there's a breakup available. In the electronic format, one has to fill up the just one figure, the total figure, but not here, there's a breakup. My lords will find page 672, note opening stock. This is the raw material part. Opening stock, note for lead, it is the quantities are mentioned. No, these are the ingots. The lead, 45 is the figures are mentioned, but I don't need to trouble my lords with the figures. Then there's a heading called Mashkura. This is the unit with which we are concerned for refined lead stroke alloy. So that is the fifth column in the third last column. The quantity of lead which is used 112.7750, lead concentrate so much, lead scrap so much, and the total is there. And then what kindly see at the bottom, where they mention opening stock, purchases received from job work, transferred to finished goods, closing stock, raw materials consumed. And then below that, the last item, percentage of yield. So 88.10. And just above that is the production. So there are and this data is prepared on the basis of the records maintained. It is the yield part is there. Note a glimpse of that. If my lords are pleased to see page 661. This is not a part of the tax audit report, but not just to show from where the my lords will find out the item wise. But it is so for lead ingot, what is the recovery? But for scrap, 62%, lead ingot is 99%, scrap is 62, constant is 39. And then what can you see at the last row, that 88%, which is the figure mentioned in the tax audit. So they have to, these records are there. Without these records, the tax audit report cannot be filled up. So this I needed to show because the tribunal has said there's as if the yield is has not been furnished. This is a part of the record itself. Now, if I may take my notes to the volume 1, my lord, page 36, the first letter, my lord, which I got from the assessing officer.
Page 20.
Page 36, my lord, volume 1.
Yes.
But I'll trouble my lord with the opening, the second paragraph. We have been directed to furnish to you copies of income tax returns for assessment year 17 and 18, 17, 18, and 18 and 19 of below mentioned IT PAN holders from whom we had made purchases during assessment year 2018-19, which are neither in our possession nor the customary trade practice, nor the suppliers are obliged to furnish the same to us. Then, however, we have communicated your notice to the concerned persons via letter dated so and so requesting to mail the above requirements immediately, and the same will be forwarded to you as soon as they are received. Copies of said letters are enclosed. Your Honor may directly ask the suppliers to submit copies of income tax returns. We cannot force them to supply copies of income tax returns. You have mentioned that the suppliers have not furnished their GST returns, but as per our record, they have submitted GST returns, which is evident from status of GST return filed by us. Input credit was duly allowed on all these purchases. So, I mentioned this. Can you see the next page? I enclosed copies of letters sent by speed post to the 4 parties and extract from the search report of the GST returns. Now he issues me a show cause notice, which is reproduced in the assessment order. If I may trouble my lords with the assessment order, that page, that portion of it, kindly have a look at page 25. It's a part of the assessment order, but may I place it from there? Page 25 at the bottom, it's the portion in italics, in quotation.
Yes.
On verification of Insight portal, it is seen that following parties from whom raw material is purchased by you have not filed the returns of income for financial year 2017-18, assessment of 18-19. Serial number, PAN of the party with name, purchase reported GSTR, purchase during the year, which is what I have claimed, amount in rupees paid during the year for purchase of raw materials, and name under which business carried on by the PAN holder. But, come back. So, the officer mentions the PAN numbers of the purchases, what they have shown in the GSTR, what I have claimed, and how much I have paid, and the names under which they're carrying on business. So, this data is there with them. Kindly see the last row, total 45 crores is what they have shown, 45 crores, 60 lakhs. 57 crores, 49 is what I have claimed to have purchased from them. And 5709 crores is what I have paid to them. Then he says, as per the record available, none of the holders of PANs have digital footprint, that is email ID. Hence, the department could not issue notice under 133(6) of the IT Act to the above parties due to non-availability of email addresses. Therefore, genuineness of these parties and transactions carried out by you with them could not be verified and are doubtful. Therefore, you are requested to prove the genuineness of purchases made from these parties by submitting necessary documentary evidence, such as ledger account of these parties in your books, purchase bills, delivery challans, entries in stock register, email addresses, relevant portion of your bank statement, as well as that of purchase parties, copy of ITR for assessment at 18-19, computation of income of these parties, etc., for verification of the identity of party and genuineness of the transactions. If you fail to submit this information, it will be presumed that you have nothing to say in this matter. An amount paid of rupees 57 crore 9 lakh will be treated as bogus purchases and added to your total income, which may be taken note of. This was the notice note. May I trouble my lords with the reply because the AO is not.
But just before that,
Lordship.
The first document they want is ledger account of these parties in your books.
Yes.
No difficulty.
I've given all that, right?
Purchase bills, no difficulty. Delivery challenge, yes.
Yes.
Entries in stock register, yes. Email addresses, yes.
But email address was not there. That's why I had sent them by speed post. My
You have also, when you wrote to them in page 36, you have said you can ask them directly.
Yes, and I sent them by speed post, not my.
All right. So email address is one. Relevant portion of your bank statement as well as that to the purchase party.
There I cannot give.
Your bank statement you can.
Yes.
Copy of ITR of yours you can. Computation of income.
Mine I can. Theirs I cannot. This is also
of these parties that can't be.
I cannot.
You cannot. Then reply.
Reply minute is at page minute 38. So kindly take from the second paragraph at page 38. We have already provided to you income tax PAN and GST registration of parties specified in the notice along with other details. At present, we do not have any business transaction with these parties. We are more than 70 years old company and have regularly complied with legal requirements under the income tax and other laws. Our email ID is duly registered with income tax GST. We should not be penalized for non-compliance suppression, if any, by other parties which are beyond our control. We have proposed to add so much on the ground of alleged bogus purchases. You want to treat the purchases as bogus on two grounds. First, suppliers have not filed the IT returns for financial year 17-18. And secondly, none of the holders of PAN have digital footprint. We like to draw your kind attention to our reply in reference to notice under 133.6 in March 2021. We had filed along with that letter all the details of purchases from the parties, documents in support of GST returns filed by the parties, details of payments and others requisitioned by you. We have credited entire sale proceeds of goods produced to our sales account, which were out of goods purchased during the year, and it included purchases under inquiry. So how goods sold could be produced without these purchases? Moreover, as per your draft order, you have verified the purchase from GSTR and found that supplier have shown purchase of 45 crores against purchase of 57 crores shown by us. Thus, there is a difference of 11 crore 84. You have stated that suppliers have shown sales of 45 crores to us, and at the same time, you are stating that entire purchase from these parties are bogus. If there's any suppression of sales by the seller, we cannot be held responsible for that. As per the decision of various high courts, it has been decided that, well, I'll leave aside that legal part. Then on the next paragraph, as per natural justice, also when the entire sale price of goods sold out of goods manufactured from purchased goods is treated as income, how the entire purchase can be added to profit without adjusting corresponding sales. Profit shown on sales is quite reasonable, so no addition should be made. The alleged bogus purchase is denied, needs to be cross-examined with the accounts of the suppliers to whom all payments were through banking route against their invoices for supplies to the company. Now we are also enclosed details document in support of genuineness of transactions. The entire purchase invoices in the inquiry pertain to the purchase of remelted lead at Pashkura unit during July 2017 to March 2018. Month-wise summary of raw materials register showing quantity of receipt, issue, and stock is enclosed for above. Date-wise entry of raw material register of lead received during July 17 to March 18 of above is also enclosed. It includes imports also. Month-wise summary of finished goods purchased or production of Pashkura unit showing quantity of opening stock, production, dispatch, and closing stock. Summary of sales during financial year 17-18 as per audited profit and loss account, showing both quantity and value for each type of sale. Please note that in case of job work sales, raw material is supplied by vendor for supply after conversion. It does not involve material cost in the sales invoice. Hence, it is adjusted to calculate sales from purchases. Statement showing the computation of sales out of above purchases and profit element thereon. Then copies of ledger account.
Yes, 330. 330.
Gotcha. Copies of ledger accounts of specified parties for each party along with purchase invoices raised by party mentioning transporter's name, relevant page of bank statements highlighting each payment made all by banking mode in support of entries in the ledger. Please note that raw material and finished goods register contains only quantity details and value details is as per ledger. Copies of invoice excluding GST for which input credit is availed. Two parties inquired by you are not suppliers of materials, but transporters for numerous purchases, and that ledger, invoices, payment details, bank statements are also enclosed. Under this circumstance, we would request you not to make any addition. Now, this was the reply. Now,
At least to the extent of this 45 crores was relief granted to the SSC.
no. Not, not, there was, the total was 57.
57, 49,
57,
09 something.
8 crores, 74 lakhs is the GST component that relief the tribunal has granted.
Tribunal has granted.
But not the rest, 45 crores, not 48 crores has been added. Not the difference between that 48 and what they have shown is 45. So it's about actual difference is 3 crores. That is not, they have shown less. I have shown not 48 crores, they have shown not, the real difference is only 3 in that sense, because the 8 crores is on account of GST itself. Because when they show, they will show the taxable value, which does not include the tax. So that's why it's 45. Now, the assessing officer's findings, kindly see at page 27. In paragraph 4.2.
Yes.
4.2. The reply of the SSC is duly considered but not found to be acceptable. As per the information available, the total purchase as per GSTR from the 7 parties are rupees 45 crores 65 lakhs. However, the SSC has submitted details of total purchases from the said parties at rupees 57 crores 49 lakhs. As per the records available, none of these parties have digital footprint, that is email ID. Hence, the department could not issue notice under 133(6) to the above parties due to non-availability of email address. Therefore, genuineness of purchase of these parties and the transactions carried out with them could not be verified and are doubtful. From the data of purchases, it is clear that there is a large difference in the purchase reported by the SSC as against the purchase made from these parties reflected in GST data. It can be interpreted that the SSC company could have made purchases from grey market in cash payment and obtained accommodation bills from these 7 parties. it can safely be concluded that the SSC was well aware that purchases were not made from the 7 parties. Despite this, SSC claimed purchase from the said 7 parties in the books of account. The SSC has produced sample bank account extracts showing payments to these parties. The courts have also held that merely because transactions have been made through banking channels, the same are not sacrosanct. Hence, the very nature of the transactions with these 7 parties is doubt in nature. No confirmation has been submitted by the SSC company from the parties in question. Therefore, these purchases remained unexplained. Therefore, the same need to be taxed in the SSC's hands as unexplained expenditure. Section 69C is reproduced for ready reference. Note, this is important. 69C, where in any financial year an SSC has incurred any expenditure, but at page 28. Where in any financial, it's set out at the bottom of page 20. Where in any financial year an SSC has incurred any expenditure and he offers no explanation about the source of such expenditure or part thereof, or the explanation, if any, offered by him is not, in the opinion of the assessing officer, satisfactory, the amount covered by such expenditure or part thereof, as the case may be deemed to be income of the SSC for the said financial year.
Now, does he deal with this statement which you have given in the audit report, the raw material?
But he accepts. That's why he says that looks like you have purchased in the gray market for cash. But he accepts there are purchases.
Accepts there are purchases and there is also manufacture of finished goods.
Because not this data is there before him. I've given him, but I gave all the quantitative details also. So not he accepts.
But only problem was at the first stage. Of course, remand report stage, notices were sent and some were returned as no such person.
I'll come to that.
But at the stage of the assessment, the only reason given is
no IT returns filed and no email ID.
None of the parties have digital footprint, that's email ID. Department could not issue for non-availability.
The commissioner appeals not the first submission which was filed. Kindly have volume 3 at page 307.
Yes.
But I'll only show the relevant portion so that at page 307, the third paragraph, the following details were filed in response to the alleged bogus purchase from 7. So these are details which were submitted before the assessing officer. Then kindly take page 308. But that factual position was reiterated that the ledger copies of middle of page 308, the paragraph in the middle, ledger copies of all the parties along with purchase invoices, these were all filed. And then kindly see the next page, 309. The new paragraph. We are enclosing copy of profit and loss account, balance sheet and tax audit report proving that entire purchases were used for production and finished goods were duly accounted for in the sales. Hence, profits from sale of these purchases have already been accounted and disclosed in the taxable income and not to be taxed again. Gross profit ratio to the turnover during the year as per tax audit report was 4.98% as against 4.32 in the previous year. So that tax audit report appointed reference was made. That is also here. Now he then calls for a remand report because he finds that there's nothing in the assessment order. Now, the remand report, the copy given is here, but parts of it are not quite legible. The Commissioner Appeal has reproduced it. May I place it on that? Kindly have a look at the Commissioner Appeals order at page 46. Page 46, not the bottom part. It's in volume 1, bottom part. The opening part I need not place. Kindly see at page 48, the last line. Yes, but the last line, as directed, notice under section 131 of Income Tax Act was sent through both through ITBA module and through speed post to the following 7 parties from whom the purchases were claimed to have been made. Now, after the first table, then, but out of 7 parties, the above notice could be served by the Postal Department only to the party named Ashish Mishra. Remaining 6 parties to whom notice could not be served by the Postal Department are as follows. Now, this table, the second table, kindly see the second last name, refused return. So, as such, that party was there. So, one was served, one refused, and therefore it was returned. The others, they say, could not be found. Then at page 50. Yeah. Hence, identity of the above persons, creditworthiness and genuineness of transactions made by the SSC with APL metals could not be ascertained during remand proceedings. Moreover, though the notice was served to Sri Ashish Mishra by the Postal Department, Sri Ashish Mishra did not appear for personal hearing fixed as per notice under 131, for which the creditworthiness and genuineness of the transaction made by Mr. Mishra with the SSC company could not be ascertained. It is relevant to mention here that a search and seizure was conducted on various residential and office premises of APL Group, including the SSC on 7 December 21 and subsequent dates. Search warrant was also executed in the name of the SSC company. During the course of search and seizure operation, books of account and incriminating documents were seized. Accordingly, the SSC of the group were centralized to this office under a single AO for coordinated investigation. Subsequently, the appraisal report along with the seized impounded documents and other related documents were received in this office in due course. On perusal of the appraisal report, it is found that 6 out of the above mentioned 7 individuals in question have made transactions with APL Metals, that is SSC company, by way of issuing bogus bills, and creditworthiness of them are under suspicion as they have not filed their ITRs for the relevant assessment years. Analysis of seized impounded documents show the following findings. Letter notices of Superintendent Headquarters Anti-Evasion, CGST and Central Excise Howrah Commissionerate were seized from the residential premises of Shopon Shashmul. He is one of the suppliers, Uttarpara, which could not be explained by the SSC. It may be mentioned here that Sri Shopon Shashmal is one of the directors of Shashmal and Nath Engineering Private Limited. Here in this case, he is the proprietor of NB Trading Company. During the search proceedings case of the group, a team was sent to registered address of Shashmol and Nath Engineering, which was found non-existent. Thereafter, one search team was sent to the residential address of Sri Shopon Shashmol, who is the director of Shashmol and Nath Engineering. During the course of such proceedings, statement of Sri Shopon Shashmol was recorded on note under section 132(4), wherein he has stated that he is a plumber earning his livelihood from his profession. His company has not supplied any goods to any person. Relevant portion of statement of Sri Shopon Shashmol has been reproduced hereunder. As per MCA data, it is seen that you are additional director of Messrs. DAG Creative Media Private Limited. Also, as per information available with the Income Tax Department, 2 proprietorship concerns, namely NB Trading and SS Trading, exist in your name. Please state where the books of account of your proprietorship concerns are kept. Please offer your comments on the issue. Sir, I do not know anything about this. I even do not know the meaning of books of account. Please state your source of income. Sir, I'm a plumber by profession and I earn rupees 500 per day on an average. From the above discussions and your previous replies, it is now amply clear that your proprietorship concerns and Mrs. Shashmol and Nath Engineering Private Limited are shell entities and had no real business whatsoever. These have been formed for the sole purpose of providing accommodation entries, raising fake GST invoices, passing on bogus ITC. Please offer your comments. Answer, sir, I agree with the above. From the statement of Sri Shashmol, it is amply clear that Mrs. NB Trading is a shell entity providing bogus bill only. Now, if I may just pause here, this gentleman, he is a director of two companies, as the statement shows, Shashmol and Nath Engineering, and then additional director of DAG Creative Media. And it is a proprietor of two concerns. NB Trading is the concern with which my client has dealt. But he has filed GST returns. He does not file income tax returns. And then it is, I would submit, it only serves his purpose because he has not filed his income tax returns.
No, he says that he doesn't know the thing, something like that. And the other person says that he was unemployed and two of his friends wanted his details.
Yes, so the other, my lords have read. The other person says that his papers were
has given an online complaint. Police complaint.
If his document, let us say, if his documents have been used, that does not show that the transaction.
No, by and large, based on this statement, question and answers, and the fact that they have not filed income tax returns, he comes to the conclusion that they are all bogus purchases.
Yes.
Long and short of the story.
I of course had asked for cross-examination because the transactions are.
Yes, in your reply at page 38 that you have mentioned.
But even before the commissioner, that request was made. If my lords are pleased to see,
the alleged bogus purchases is denied and needs to be cross-examined with the occupant.
Well, that was at the assessment stage.
Assessment
stage, and then
cross-examined with the supply it's cross-examination of records, not of the witnesses.
No. Cross-examined with the accounts of the suppliers to whom all payments were through bank through.
It's cross-examination in that sense. You have to examine their records and
because that stage there were no statements. I was not aware of any.
But it's the statements were recorded after the remand report was called. No.
Seems there was a search on 7th December 21.
Based on that seized documents, etc.
Yes. The documents, there were nothing. Their entire case is based on these two statements. They're not pointing out any document which is not incriminating.
Oh, during the search proceedings, these statements were recorded.
Post-search, not
post-search.
Post-search. The search was post-assessment. These the assessment happened on 20. It's a date of the assessment.
That is, after that, they have received the appraisal report. In that appraisal report, all these statements are there.
These two statements are there.
So, before the appellate authority, you sought for cross-examination.
Yes, now, kindly see my reply.
Page 53 bottom. Rejoinder to the remand report.
Lordship.
We have received the copy of so and so. Assumption of services. AO stated search under so and so. Assessee has also faced harassment due to non-filers of so and so. 7 individual, etc. So when the remand report was called for, the assessee would have been given an opportunity.
So this report is based on the appraisal report itself.
No opportunity given to the assessee.
The first response is not to the remand report itself, in which the assessee says, because the officer had issued notices, they came back. One person did not turn up. And
assessee was given an opportunity because they say in page 54, the extract of your rejoinder to the remand report.
But the remand report, normally what happens is the remand report is sent by the officer to the commissioner.
And at times what happens when the remand report is called for, the AO is free to issue notice to the assist and collect documents, statements, and then
in this case, the reading of the remand report shows that what he sought to do was send notices which came back. One was served, the rest came back, one was refused out of them. Now, thereafter, he's gone into the appraisal reports. That part is not given to me. That is something which he finds out from the departmental records. Appraisal report is never given to the SSC. He puts it in the report. Then I filed a rejoinder to that because that report is disclosed to me. But at page 55, my lords, please see at the top, or the second bullet note. And the cross-examination is in the paragraph following that, the request note. And also seen that page 55, the request for.
But these statements were never confronted with yes. Which responses given above cannot be considered conclusive evidence for treating any transaction. Or some of the statements were later retracted with respect to parties. No incriminating material was found.
And the next paragraph also.
We were not provided an opportunity to cross-examine them, aiding during assessment stage. Although we are specifically asked why the letter dated 9th July to the show cause notice on the Andaman timber. So you say that the principle under section 68 cannot be applied for 69.
But because I'm buying as long as the goods come to me, and I have paid
but
for
the AO, while completing the assessment, has accepted the fact that as per the GST portal, some 45 crores and odd is reflected.
45 crores, the reason if I may just, I'm repeating myself, that 45 crores is without including the tax amount. 45 crores is the amount on which tax will be charged. So the tax charge is 8 crores 74. So 45 and 8, it becomes 53. The real 53 something,
57.
The real difference is 3 crores, not because that the tribunal has ultimately sustained 48 crores, which is whereas they have shown 45. The GST part, the tribunal has, in fact, that's accepting a part of the transaction. Once the tribunal allows credit on account of the payment made to the suppliers of the GST amount, 8 crores odd. So
the purchases cannot be doubted.
No, it cannot be. The tribunal has not completely. But
what was the time gap between the purchases and the search? How many years?
That this is not assessment. Our assessment here is not
18-19.
So our assessment is so financial is 17-18, and this is happening after 4 years.
4 years.
The summary at page 56, bottom where the assessment.
I'm reading 56.
But after this, another submissions was filed, which is not taken note of here. But my lords will have it in volume 5, and not page 310.
The rejoinder to the remand report is at page 82. He has extracted it.
Yes, the document, my lords will find at page
82.
Lordship. Page 87 is the next set of submissions which was filed.
That is, this is after the remand report, your rejoinder to the remand report,
Then for the
second submission.
The particular relevance is Roman 4 at page 88.
'89 Sapara 5 did not provide opportunity crossing, those specifically asked. For movement of goods also, you have produced documents transported, and you have downloaded the GSTR 2A. And that serial number of the invoices show that in the interregnum, the supplier has issued invoices to others as well. Now, where are the page 58 is the finding of CAT.
From page 65.
65.
Middle of the page.
Yes.
But I may only point out, its findings start at 65, not from 67 to 74 are the decisions not on share capital and loans not. So not kindly not have page 65. Not kindly see at page 66. Middle of the page. From the material on record.
From the material, yes.
I find that the appellant has not been able to discharge his owners at all with regard to the impugned purchases. He has not been able to prove even the identity in the context of the impugned transaction of the claimed sellers of goods. Out of 7 such sellers, in the case of 4, there is no trace of these entities' persons. In the postal department or the department inspector has not been able to trace them or serve notice upon these. The appellant, of course, has unequivocally stated that it is not his duty to prove that such persons actually exist at all or not. But that was never my case. How could I say that I don't have to show that they exist? Not I did business with them. So, but later in point of time, after 4 years, not if I cannot, if I have no existing relationship, not I cannot. If I can't get hold of them, I cannot get hold of them. That was my stand. According to me, is not bound by law to prove to the assessing authority that such sellers do have a physical existence and that they are credit worthy to carry out transactions running into several crores. But physical existence part, not they're PAN holders, not they are GSTR registration holders. They're filing GSTR returns. So, not the identity and existence, not it is by itself taken care of. All these facts take care of that. Creditworthiness is something I disputed that in law, I'm not required to show my supplier's creditworthiness. Then what can you see the next paragraph? Going by the process to be taken by law in such a case as this, it has already been mentioned that the primary onus for establishing the bona fides of the impugned purchases lies by law on the appellant, since it was he who was asserting that these purchases were bona fide and genuine. I find that except for providing a whole lot of paperwork in terms of purchase order, ledgers, some bank accounts, monthly summaries of raw materials, monthly summary of finished goods, summary of sales as per PL account, etc., details which had also been provided by the appellant during assessment, the appellant has done nothing to prove the genuineness and bona fides of the impugned transactions. He has been asked specific questions in relation to very specific purchases. Appellant's reply has been based upon generalized figures of sales and purchases. Now, all the transactional documents are just being brushed aside by simply saying this.
So he harps upon that 7%, did not appear.
And that 2 of them said that they didn't do this.
One is plumber, one is crane operator.
On the middle of page 67, just the first sentence, his entire approach in this regard, in my opinion, is based upon an erroneous reading of the legal framework within which these issues are to be examined. Then what he, up to page 74, I've gone through the case, either it's share capital or not, it's a case of loan. Up to page 74 at the top. 74, the continuing paragraph.
But these are all section 68 cases.
68 not all share capital and loans, but I've by name, they can be identified as, and the discussion that he has made, they're all loans and share capital. Because not in case of purchases, the law as I found it, is that if the goods have been purchased from elsewhere, and there's the actual suppliers are different from shown in the books, then add something for the difference, because the book, it may have been overvalued, the purchase may have been overvalued, but not that you disallow the entire purchase. Well, that is the trend of authority. That because the goods have been used to manufacture and then the finished goods have been sold, because you're just excluding an entire set of expenditure, whereas you realize that goods have been purchased, but the sales side is undisturbed. So
on which tax has been paid.
So therefore, the trend of authority, I've got decisions. In fact, I've got a decision which says that once the purchaser in the books of account, 69C does not apply at all, because the source is in the books. Now, at page 74, the paragraph in the middle, again, he starts, what is, there's some finding which is recorded. In my submission, there was no basis for him to say that. But kindly see the paragraph in the middle, but the last 7 lines, paragraph in the middle. It is a special investigation that have been brought on record at the search, post-search, as well as assessment and remand stages that have brought to the fore the extent to which the appellant has been falsifying his books through the booking of bogus sales. Where does he get that? There's no. Does he mean bogus purchases, or does he mean? But there's no foundation for.
There's no such allegation here.
No, nowhere. And then at page 75, the paragraph starting in the middle, 6th line from the top of that paragraph. The entire purchases were found to be artificially manufactured by creating false paper trails, both through the books of entities that had been created by the appellant himself and at his instance, and through false paper trails within his own books. So he says that I had set up those people, and where does he get any of this?
But how does he deal with the GST returns filed by those parties?
But he says it's all papers, those all documents. It doesn't mean anything. Remember, there's one part
on which credit has been allowed to those parties.
He completely, he thinks these are all paperwork. It has no significance or relevance at all. But also, at page 75, one more thing I need to show. 6th line, in fact,
not his responsibility to refute the statement.
Yes, no, this is
incorrect.
I had asked for cross-examination. At page 76 at the top note, he says that it was for me to establish the credit worthiness of the suppliers. Then at page 76, with this new paragraph, a little below the middle, where he considers the other aspect. But he
goes to the extent of saying it's a circular transaction.
but where is not the he's
Withdrawn cash, this, that.
Because he says that in order to because not this argument, alternative argument was supported by authority to say that look, the purchases have taken place. Maybe if it's not from this person, it's from somewhere else. So you look at the difference between the. So he says no, you have to own up. I've not even been granted cross-examination. He wants me to own up that I have purchased from elsewhere. I have to give him an account of how I purchased from elsewhere, from whom I purchased it. Because otherwise he accepts that yes, this could. Then he says you have not given details of consumption, and you normally those details are all there. Is completely
no sale is not disputed. The production or whatever the finished product, that is not disputed. Only this portion is questioned. No, what happened in the
tribunal? The
tribunal?
tribunal kindly have the tribunal's order. It is that page.
We will have it from the memo of appeal.
Very well.
Easier to handle.
Well, I'll tell my lords the internal pages in that case.
Yes.
If my lords are pleased to have it at page. Internal page 28, paragraph 14.
Yes.
Paragraph 14.
Where from the tribunal says you purchase scrap.
Lord Tribunal, and then this in next, namely lead ingot. So it is lead ingot, they've equated lead ingot with scrap.
There are three items actually.
Lead concentrate, lead scrap, and lead ingot. So good recovery can vary when it comes to scrap. And the uh,
The first 27 pages of the order is extract of the submissions, grounds of appeal.
mainly, the Commissioner's appeals order has been reproduced, which is from
In para 17 at page, internal page 30, tribunal refers to the solid machinery company.
Gotcha.
That's a 68 case or a 69C case?
But this was genuineness of purchase transaction.
But there factually, I think there's something different. In those cases, no payments were made. And the theory they said was the goods were defective and that was disbelieved, stating that after 2 years, you have done so. And there is another decision of Delhi High Court, Mahalakshmi Day. Let us see the substantial questions.
Gotcha. And that page 18. I'm sorry, in the memo it will be different page. But on but I, on the cross examination part, Andaman Timber, I don't need to spend time on it, just the copy for the purpose of recording. But the paragraph 6, if my lords are pleased to have, and then a conclusion in paragraph 8. Paragraph 6 note in the middle, even when the assessee disputed the correctness of the statements and wanted to cross-examine, the adjudicating authority did not grant this opportunity to the assessee. Paragraph 8 note this, it was held that if they are excluded, then there was nothing to. I'm not on the application of applicability to section 69C, not in case of purchases which are in the books of account. But the Honorable Delhi High Court But paragraphs 1 to 6 note will bring out note the position note.
Paragraph.
Note 1 to 6 note.
Hopefully. Source of expenditure.
No, then that source note is not in dispute.
That is not disputed.
Now, but but in a case where not the genuineness of the purchase is disputed, but where it has not the case is that it has been procured from elsewhere. But the approach of the courts has been different. Not kindly have a look at the judgment note of the. Note paragraphs 5 to 8 at page 455. Note.
Paragraph 5.
5 to 8. Note at page 455.
This is for an alternate submission.
Yes, but for the that is the approach. But ultimately, if it is found that the goods have come from elsewhere, then what has been the approach of the courts? Whether the entire thing is
just the opinion of the assessing officer at the first instance.
Even the commissioner appeals, he saw substance in it, but he said you have not owned up to it. If you had, according to him, I had to own up to the allegation that I had purchased it from elsewhere and give an account of that. The Bombay High Court not also on the same. I'm not kindly. But at page, the questions are at page 522, paragraphs 3 and 4, where the court has not summarized the controversy, and then at page 527, 17.1.
Here, cross-examination issue also is there.
Yes, but the judgment of our court note where the supplier is not available at the time of inquiry, on that note, paragraph 9 at page 114.
This was a case of 3 years.
The last decision notice of the Honorable Supreme Court, I should have actually not placed this after Andaman Timber. But this is a case not where originally the appeal was dismissed on the ground of low tax effect. Then a review petition was filed. So the Supreme Court examined the matter on merits and said that revenue doesn't have a case note. The last two pages, note page 318 and 319. But they're also case of a third party statement, no cross examination was allowed. (318) and 319.
When you'll make your submissions? Anjan, we can continue this on Monday. You said Monday is group like admission. How many matters will be there? Otherwise we'll forget. That's all. This is continued. What we practice. Monday we will have this one, so that we'll have continuity immediately after fresh admissions. Probably in 10 cases will come. Enough.
Lord, if for any reason, Lord, I'm not here, Lord, my lords may continue with matter, my learned junior will be.
Though it appeared bulky on facts, it was very narrow issue.
But the orders were long, therefore, Lord.
Yes, yes. Punching, putting. So, Mr. J.P. Ketan, Leonard Senior Advocate, has concluded his submissions for the arguments on behalf of the revenue list on Monday.